We're back on. So it took me a little bit longer to get back on. I was getting a copy of the request to charge, Mr. Gough, that you filed today. I see you filed another motion for mistrial.
A motion a day. Not literally.
Flipped away, but
This is actually a different motion for mistrial. I wouldn't file the exact same thing. That would certainly try the court's patience. This is a legal theory not pursued in the Musladin case that's been previously referenced, although these two cases are cited.
well, let's go ahead and take it up then. We'll get back to the charge in just a moment. I didn't realize I had another motion for mistrial, which needs to be addressed on a timely basis. So this is the first time I become aware of it. I'll go ahead and see, Mr. Gough, what you have.
Your Honor, we've cited Moore v. Dempsey and Frank v. Mangrove. Their case is cited footnote in the Musladin case, but we're filing this motion for mistrial based on inherent prejudice in the proceedings in the case. I have recounted, incorporated in all the previous issues that have been brought to the court's attention. I have added information, I believe, since the last time we addressed the court on the related motion. And I have also added in a couple more articles relevant to this matter, and I have attached the photograph that I took yesterday. I think that's Exhibit 1 of what the demonstration looked like yesterday on the lunch break from the steps at the top of the foyer to this courtroom. And you can see, Your Honor, that not only are the individuals participating in this event well within the First Amendment perimeter that we had requested at the beginning of the trial, they're well within what I understood to be the court's parameters for that. You can see speakers. I can't identify them from behind and their views obstructed, but they are the speakers at yesterday's event who are apparently several well-known, nationally revered figures in our country, speaking literally at the front door, I would guess 5 to 8 feet, probably 7 to 8 feet, beyond the front door to this courthouse. I see what looks like a microphone stand in between them. They are literally, you can see the gentleman to the rightmost gentleman is literally standing next to the pillar of the courthouse, Your Honor. This is an event that is literally at the courthouse door with more people than I can count outside. We have police barricades, but even the barricades themselves are barely go past the flagpole. Your Honor, in the attached articles, it's 2 and 3. We've got multiple Black Voters Matter signs outside. We've got a T-shirt. I can't read in this picture, but I'm sure it's not flattering of Mr. Bryan. We have another article that's attached, which has, of course, we also have a bunch of folks here that have been referenced previously in this case. But in the next article, we have the Black Pastors Matter sign outside the courthouse in an article about the same event. We have another picture from a different angle, and again, you can see, Your Honor, that the police barricade barely goes behind the courthouse flagpole. And again, you can clearly see you've got people up on the courthouse steps during this event, literally standing. It looks like one of them's leaning against the middle courthouse pillar in this case, for this courthouse, Your Honor. And you have Pastor, and that's Exhibit 4, you have Pastor Jamal Bryant, a revered figure in both the liturgical community and the community at large, calling for a prayer wall against racism amid the Arbery trial. I can't say that I was outside. I don't know if they completely ran around the courthouse as they intended, but clearly, again, there's a lot more going on here than ministry. This is advocacy against our client, and it's troubling. Directing Your Honor's attention to Exhibit 5. This is a picture, which I don't know why the printer is not better than it is. It's brand new. But Your Honor can see, and I'm sure Your Honor has been seeing through the trial, the public gallery, we know that the first pew is cordoned off for security purposes. And then we have 2 other full pews, or benches, and then we have a partial bench behind it. The picture is taken from the second seat on the front row of the jury box. I think it was yesterday. And it's very clear that that location, which is where juror 380 sat for much of the first week of the trial, I've lost track of where they all sit. They changed from recess to recess. But it's pretty clear that pretty much everybody in the jury box, which is, depending on the time, 9 or 10 out of the 12, have an unobstructed view of the gallery in this case. Now, you know, I have asked the court, and I understand, you know, there aren't a lot of cases on this issue. And the Supreme Court itself, although it's given an indication, several of the justices on the First Amendment issues, they are technically open. So it's not that I don't appreciate the struggle that the court has in dealing with all this, but we have several jurors who would seem to be subject to influence or intimidation just by the comments that were made during the jury selection process. And it's particularly, Your Honor, you know, we have an issue with juror 380 at this point. I don't know what to do about it.
Well, I've read the motion, I've seen the facts, and you don't need to go over it.
Then I won't. But I have made it, filed the motion for the record. I stand on the argument that was presented. I would ask the court to grant a mistrial of this case based on the inherent prejudice to Mr. Bryan.
From the remaining defendants. Understand. Hearing nothing.
Yeah, I think what we were just discussing, Your Honor, is that the court has made us aware that you're checking in with the jurors, and you're doing that regularly. Obviously, you can't do that today. But by Monday, we would hope that the court would again check in with the jurors to make sure that nothing has happened over the weekend where they may have learned about this, got notified about this, and feel a certain way about it, by simply reminding them to talk with you should they have seen, heard, or gotten some information. And at that time, if the court reports back, then we might have something to talk about.
Your Honor, on behalf of Greg McMichael, we take a similar position just expressed on behalf of Travis McMichael. Our position is that the First Amendment assembly of these people to say what they wish to say is nearly sacrosanct. We have no issue with it at all. Our concern, as just expressed by both counsel for Mr. Travis McMichael and Roddy Bryan, is whether it is having any influence on our jury. And right now, I don't know if it has or hasn't. I take it that we're depending upon the jurors to self-report each day based on the court's instructions to them each evening. I hope that's sufficient. But if after the verdict comes in, if there is a verdict, and we find out that jurors were exposed and didn't report it, it could create problems then on appeal from any conviction. But right now, we don't have any facts upon which to base a motion for mistrial based on jurors being influenced by the public, though it does concern us. So the balance between their freedom to say what they wish, which we respect, and our right to a fair and impartial jury, uninfluenced by outside forces, is what's at stake here. And again, we just depend on the court's authority to inquire of them whether they have been exposed and influenced in any way by anything that's going on outside this courtroom.
May I add one more question? Yesterday was the first day where there was, really the first and only day where there was a larger crowd and bullhorns. The idea that a juror could hear that during deliberations is of great concern to us. And so we're perhaps inquiring, and it doesn't have to be done here in open court, that the court also is aware that if those sounds could come into the courthouse, that they'd be prohibited.
So I'm not going to say where the jury deliberation room is, and because I think that just creates the possibility that folks could try to figure out where in the courthouse would be appropriate. I will tell you that whatever was going on outside yesterday, and I think you're right, yesterday was a significantly larger crowd than we've seen most days. I don't recall any disruption in the courtroom itself. Where I was for the day yesterday, I did not hear what was going on. I'll make sure that we check and make sure that there isn't any outside influence that is or could potentially affect the jurors during deliberations. I think that's an appropriate step, and I'll go ahead and do that. From the state.
Thank you, Judge. We ask that you deny Mr. Gough's motion for mistrial. There's absolutely no evidence here that the jurors have been influenced in any way by the first and only larger crowd that came yesterday. No evidence that they even knew it was out there. No evidence that they have been intimidated or influenced in any way. Mr. Gough then says witnesses are subject to intimidation as well. No evidence has been presented of the witnesses coming into this courtroom having been intimidated in any way, shape, or form. And then he brought up the court itself and intimated that the court might have been influenced by all of this.
I object to that. That's a mischaracterization of the motion.
It's on page 6.
Yes, I'm aware, I wrote it this morning. It doesn't say that. It says that the concern is that people are attempting to influence the presiding judge. That's not saying that the judge is being influenced, but I'll come back to that when I have the last word.
Your Honor, Mr. Gough is a brilliant lawyer. These briefs that he has filed are detailed, and he has filed a ton of pretrial briefs that the state has had to respond to. He is very, very smart. He is very, very calculating, and he's a good lawyer. Because on November 12th, he stood up in this courtroom, knowing full well he was on television, and made comments about Al Sharpton and then black pastors and Colonel Sanders, all knowing full well it was being broadcast on television. That was not ineffective assistance of counsel by any stretch of the imagination. That was strategic. He got the response he wanted because he has filed a motion a day based on a continued drumbeat of, well, see, people are coming and people are responding, but they're responding to what he did. They're responding to what he strategically, knowingly, intelligently did so that there would be a response so that he could then complain of it. That is good lawyering right there, because now he's motioned for a mistrial based on something that he caused. You cannot insert reversible error into the case yourself. You can't go ahead and do something and then go, oh, well, it's reversible error when you're the one who did it. But he is attempting to go ahead and do that, which, by the way, once again, not ineffective assistance of counsel, brilliant lawyering, and we ask that you deny his motion for mistrial.
Of all the things I've been called all around the world of the last month, I don't think brilliant was any of them. But let's take this up, Your Honor. The motion was legitimate. I didn't ask for anything that wasn't done in federal court 30 years ago. Because it was intuitively obvious then that it's a problem. It's intuitively obvious today that it's a problem, and it has been. The idea that a lawyer standing up to defend his client with appropriate motions made in a courtroom somehow can waive the client's rights by having raised the issue, that's a troubling concept, Your Honor. And let's be clear, this motion is not a motion to recuse. We have never filed a motion to recuse in this case. We've never even suggested that the court should do so. We've asked all the court officers in this case to disclose any basis that might arise, and we assume that when we don't receive information, that there's nothing to discuss. That's not the issue. The issue is the attempt of people in the media or people using the media, particularly people that are associated with the Arbery family or their lawyers, whoever it's coming from, however it's coming, there is pressure being exerted on these jurors. There's pressure, consciously or unconsciously, being put on witnesses. There's pressure, conscious or unconscious, being placed on this court. That is the problem. It doesn't matter whether the jurors are being influenced. It doesn't matter whether the court is being influenced. It doesn't matter necessarily that the witnesses are being influenced. But it does raise serious questions about the propriety of the proceedings and the integrity of the process itself. It is unfortunate that this case raises in a way that maybe hasn't come up before, with the activities of third parties. Now, I'm not saying that the state had no role in any of the stuff that's gone on in media frenzy or the GBI from the beginning of this case, but obviously much of what's happened is the result of third-party activity in this case, spectator activity, for lack of a better phrase. The state's fundamentally mistaken, and I think the court is not giving full credit to the argument that's being made here. Yes, if there's actual prejudice here, if the jurors are all staying up saying they can't be fair, if Your Honor were to stand up saying you couldn't be fair, if a witness were to stand up saying I can't feel like I can tell the truth, that would be actual prejudice. And we wouldn't be having this discussion. The court would, on its own, sua sponte, be taking appropriate action to ensure the rights of these defendants. I have no doubt about that. The question here is inherent prejudice. That does not require any affirmative activity in the gallery. It doesn't require any affirmative statements of jurors or anybody else. The argument is that it is inherent prejudice. Now, this is not 1915. This is not 1923. There are not thousands of people outside with pitchforks in baseball bats. But I would respectfully submit to the court that this is the 21st century equivalent. This case has been infected by things that have nothing to do with the guilt or innocence of these defendants, largely without as far as I can tell, it's not like the state is out there during this trial giving press conferences or something, but still, third parties are influenced in this case. They've been doing it from the gallery in this courtroom. They've been doing it outside. This is what a public lynching looks like in the 21st century, with all due respect. They don't have to have 10,000 people outside. They don't have to have 100,000 people outside. Perception is reality. We have sealed these jurors off. We hope we have. We have sealed them off. And it doesn't matter how many people are outside. It doesn't how violent they appear to be. It doesn't take much. And you've got witnesses and you've got jurors who are worried about their careers and their livelihoods when this case is over. And they'll be aware of what's going on. They certainly were aware of it before they got here. They talked about it during the voir dire process. Just because they haven't put a gallery up, they haven't put a podium up outside with a hangman's noose on it, doesn't mean that this isn't a trial, despite the best efforts of this court. This isn't a trial that's been infected by mob violence of a woke left mob. And whether people realize that they participated in that or not, I'd like to think that the vast majority of the people outside this courthouse really have no interest in anything but justice. I want to believe that. From a lot of the people I know out there, I think that's true. But the perception is the reality. And the media have fed that perception and created a reality, whether it's true or not. Just like other people have created a false narrative, and the falsity of that narrative has been made very apparent through the trial of this case. That becomes the reality. This is what a mob-dominated trial looks like in the 21st century, and we're asking for the mistrial.
All right, the court, having heard from the movant as well as the parties, denies the motion for mistrial. I think the court's position has been accurately stated previously. I thought it appropriate, given the mistrial filed, that we have it on the record. We're going to take a lunch break. We're going to be in recess for an hour.